The Data Protection Act of 1998. The Data Protection Act came into force in March 2001 and replaced the Data Protection Act of 1984. This Act is how the UK implements the European Directive. This is a directive adopted by the European Union. This provides for the protection of all personal data collected for or about citizens of the EU, and it relates to the processing, using or exchanging of the data. The Data Protection Act is made up of 8 main principles and applies to the processing of both manual and electronic data. Number 1 states that information should be fairly and lawfully processed. This means that if we want to store somebody's personal details, we should let them know. For example, in the recruitment and selection process, we may want to store applicants' details on file, and for this we should gain their permission. Number 2 states that information should be processed for specified purposes. In HR, we gather lots of information regarding our employees so that we can pay payroll accurately or contact them in an emergency. If we use this information for anything other than those specified purposes, we should gain their permission before doing so. Number 3 states that information should be adequate, relevant and not excessive. An example for us in HR means that during an interview we should only ask questions relative to the role. Number 4 states that information should be accurate and up to date. Self-service systems help HR here, as employees can update their own records. Number 5 states that information should not be kept for longer than is necessary. An obvious situation for HR is when we're dealing with leavers. We should only keep the relevant data needed for perhaps providing references or continuing to pay pension benefits. We need to destroy any data that we no longer need. Number 6 states that information should be processed in line with individual rights. People have a right to privacy, so there would be a breach if we checked up on their private emails or listened to telephone calls without their knowledge. Vetting people for jobs by checking their Facebook page could also cause us problems. Number 7 states that the information should be secure. This means that we must make effort to prevent the loss of data. Perhaps that means that we should have locked storage cabinets, or that any email or online information should be password protected. We should also provide protection against fire or from computer failure, so we need to make sure our computers are backed up. Number 8 states that the information should not be transferred outside of the European Economic Area without adequate protection. This principle has just been updated, so we'll look at that one in more detail. In 2000, the Safe Harbour scheme was established, which enabled data to be transferred outside of the EEA to the US if US companies registered as part of the scheme. However, in October 2015, the scheme was declared invalid by the European Court of Justice. New arrangements have been agreed in February 2016, and these are called the EUUS Privacy Shield. Extra protection comes in the form of stronger protection of data transferred from the EU by US companies, stronger monitoring by the US Federal Trade Commission, and an increased cooperation with the European data protection authorities. This is an area likely to continue changing, and as such should be monitored closely by human resource departments.